So Texas AG and prospective convicted felon Ken Paxton has sued a bunch of swing states to overturn the election. What happens when those swing states sue back? Check this out. Leave your comments, ding the bell, share it with your friends, and subscribe to our channel. On July 10th, 1861, the United States Senate had a resolution introduced into it expelling 10 members of the Senate for supporting the Confederacy in their sedition. I think that in the House of Representatives, we have 106 members who are openly seditious, and they should be treated the same. But then that's me. I looked at the, I read most of Ken Paxton's pleading. I shared a lot of that with you at the beginning of the week when it first dropped. I think it was on Monday. And now I've read this was filed with the Supreme Court yesterday. In this case, State of Texas v. Commonwealth of Pennsylvania, Georgia, Michigan, and Wisconsin. And this is the opposition to motion for leave to file bill of complaint and motion for preliminary injunction, temporary restraining order, or stay. I think they misspelled temporary in this, which is unfortunate. But anyhow, this is from the states. And just to give you the, it runs about 40 pages. And just to give you the overview, this is the table of contents. Mail-in voting under the Pennsylvania Election Code, number 1. Number 2, the 2020 general election. Number 3, Texas's allegations regarding Pennsylvania have already been rejected by both state and federal courts. Next, Texas's claims do not. These are the titles for the subheads, for the for the portions of this filing with the Supreme Court by these 4 states in defense against Texas. Texas's claims do not meet the exacting standard necessary for the court to exercise its original jurisdiction. Texas does not present a viable case in controversy. Texas lacks standing to bring this issue. This untimely action is moot. In other words, hey, the election's already over. You can't do this. Texas fails to state a constitutional violation. Texas does not assert a meritorious electors clause claim. Texas has no basis for any equal protection or due process claim against Pennsylvania. Texas is not entitled to the extraordinary preliminary injunction it seeks. Texas cannot meet the high standard for injunctive relief. And Texas's request to disenfranchise tens of millions of voters who reasonably relied upon the law at the time of the election does great damage to the public interest. The question, in my mind, I told you when this first was filed, and I think we were probably one of the first places to break the news, actually, or report the news. I didn't break it. Was that I thought that, at the most there was a 5% chance that the Supreme Court would seriously consider this case and issue any sort of ruling on behalf of Texas. I think that probability now is less than 1%. It is still a threat, and the fact that it's a threat should cause all of us, Democrats, Republicans, conservatives, liberals, moderates, independents, I mean, whatever your political stripe, if you believe in our Constitution, or at least the concepts of our Constitution in a representative democratic republic, we hire representatives to do our work for us and defend and to advocate for our interests and legislate on our behalf. We do it through winner-take-all elections, which is what's called democracy, the democratic part of it. And we operate, beginning to end within the framework of law, a Republican form of government. And, this is just an absolute, full-blown, all-out assault on that, this attempt. And I think it needs to be recognized as such, and it needs to be taken on as such. And this is just a few quotes, by the way, from the counter, it's not a countersuit, from the defense offered by Pennsylvania, Wisconsin, Michigan, and Georgia. This is from the Pennsylvania Attorney General. The state of Texas has now added its voice to the cacophony of bogus claims. This is literally what they're saying to the Supreme Court, these are word for word. Its request for this court is legally indefensible and is an affront to principles of constitutional democracy. What Texas is doing in this proceeding is to ask this court to reconsider a mass of baseless claims about problems with the election that have already been considered and rejected by this court and others. Texas obviously lacks standing to bring such claims. Texas has not suffered harm simply because it dislikes the result of the election. This includes, they talk about Texas, the cascading series of compounding defects in Texas's filings is only underscored by the surreal alternate reality that these filings attempt to construct. That alternate reality, this is the state of Pennsylvania speaking to the Supreme Court about Texas. That alternate reality includes an absurd statistical analysis positing that the probability of President-elect Biden winning the election was, and then they actually quote from the Republican complaint where Ken Paxton, in his effort to get Donald Trump to pardon him, writes this thing to the Supreme Court. And literally, this is a quote from Texas's filing with the Supreme Court. The statistical probability of Joe Biden winning the election is 1 in a quadrillion. End quote. That's somewhere between absurd and obscene, right? That was part of their bill. It was item number 6 in their bill of complaints. And then back to Pennsylvania. The court should not abide this seditious abuse. Seditious abuse. You think I'm, on a high horse or yelling about these guys here saying they should be expelled from the House? Here is the state of Pennsylvania officially saying to the United States Supreme Court that the state of Texas and all of their allies are engaged in sedition. The court should not abide this seditious abuse of the judicial process and should send a clear and unmistakable signal that such abuse must never be replicated. Do I hear an amen?